Good evening. Welcome to our Rights Tonight event this evening. I am Lisa Morgan, a kindergarten teacher and the current president of the Georgia Association of Educators. Our Rights at Night event this evening is for GA members and GAE staff only. If you are not a member or part of GAE staff, please sign in, send me your information so we can allow you to be in the meeting. We appreciate your interest in GAE and hope you will join our organization today by visiting joingae.org. Everyone, please note that you must receive prior permission from the GAE Executive Committee or the GAE Executive Director before recording audio or video of this meeting. Social media posts concerning this meeting shall not contain information about the specific content of the meeting, although the sharing of general information about GAE and GAE events is encouraged. Please be courteous to other attendees and request their permission before posting photographs containing their images. If you have questions about social media posting of GAE events, please contact the GAE Executive Committee or the GAE Executive Director. Again, I'm so happy to have all of you with us today, and I know that everyone is going to learn a lot. I will say, I told Mike earlier, we scheduled this session discussing teacher contracts and our legal rights for January. After last year, we did it in February, and we had several members who told us our contract's already come out. We already had to turn it back in. So we scheduled this meeting for January, hoping we can get you the information before contracts are issued. And then we had a District 2 meeting last night, and we learned that Fulton County issued contracts last Friday. So if you're from Fulton, I hope you learn a lot. And if you are in Fulton and know other members who have questions, please make sure that they go to our YouTube page. We will have the recording up later this week so they can get this information before they sign and return that contract. So thank you all for joining us, and I'm going to turn it over to our General Counsel, Mr. Mike McGonigal, to talk about our employment contracts.
Thank you. Lisa,
Mike?
can you do you see the slides okay? Or
Yes, we see you're not on slideshow view yet. We see everything on the left as well.
Okay. Oh, now now I can't see there we are. All right. See, how do I advance these? Every time I do a Zoom, it's a different view. Let's see.
Yeah, and
yeah.
Okay.
I'll use the arrows.
If you go up to the top where it says display settings,
Yes.
click on that.
Yes.
Click it. And then see if it's duplicate slides.
It does say
that one.
Click that.
Yeah, see if that one works.
Well, now my screen's black. Okay, well, that's better.
There it is. That's it.
Yeah. Yes, that's very good, Mike. It's larger.
Yeah. Yeah, my tired eyes, I need to see what's going on. So we're gonna talk about a little bit about teacher contracts. I want to talk about some other the type of labor environment we're in Georgia, a little bit about what right to work is and what at-will employment is, and dig into contracts after we sort of look at the the broader picture of labor law in Georgia as it applies to public school educators. And my first screen is there as a reminder when you're talking with a potential member as to the advantage of GA Legal Services offers that no other organization offers. So we offer higher limits on the liability protection. Liability protection represents in the event that a lawsuit is filed against the school district and you are named in the suit. We see just a handful of those cases a year, not to downplay the risk. But sometimes there are litigious parents that sue on behalf of a special needs child, for example, claiming that they aren't receiving their services under federal and state special education law, for example. Those are a very small number of cases that we see every year. The bulk of our cases, the incoming cases, are the employment and certification defense. And the most important thing to remember when talking about legal services is that other organizations have a cap on what they will expend in legal fees in defense of a member. That's number one. And we don't have a predetermined cap. And you never know if, you know, if your case is going to have to go through up the Georgia appeals system. That's an expensive proposition. So you want to ensure that you have that protection in case you need it. The other thing that GA does is we file affirmative lawsuits against districts. Just off the top of my head, we have a suit, several race discrimination suits in South Georgia, a case in Middle Georgia regarding FMLA and the Americans with Disabilities Act. Those are pending in federal court. We've also, in partnership with the NEA and the Southern Poverty Law Center, filed a federal lawsuit on behalf of Cobb County member Katie Rinderly, who was terminated from her job for reading a book to her 5th grade class about gender diversity and acceptance of differences. So we are proud. We're the only organization that does that. So how did we get here? I know history isn't just dates, but these, I just want to put these out there to remind folks that GA is more than just a merger. When I got here a few years ago, I was talking about the merger between a Black association and a white association, and that occurred in 1970. It was approved by the Cobb County Superior Court. But it goes much deeper, as you can see. Really, the roots of GA begin after the Civil War, still during, segregated times. And then along comes the Brown versus Board of Education decision, saying that separate but equal is inherently unequal. And we saw the move to desegregate schools all across the country. Then, of course, GA still hadn't, merged. We still had our two Black and white segregated systems. We were still in Jim Crow. And then came the major push in the civil rights movement in the 1960s, which brought about our Voting Rights Act, our Civil Rights Act of 64, creation of the Equal Employment Opportunity Commission, and the Fair Housing Law, I think that was 1966. And so the culmination of that push after Brown and the civil rights movement, the NEA gave the states who were segregated an ultimatum. You can merge and be part of the NEA family, or you can, remain a separate group. But lo and behold, GA managed to, or the two groups in Georgia, I should say, decided to merge. Now, for those who are really want to read more about it, there's some absolutely fabulous books written by a retired Emory professor who studied Black education in Georgia for her whole career, her whole tenure over at Emory. She's retired now, Vanessa Siddle Walker. And her first book is about Horace Tate, who was GA's first Black executive director. And it talks about his role and the role of public education, segregated education, in playing the games to achieve equality, meaning their argument is, well, okay, you want us separate, but then you have to give us equal resources, you know, the same as a white school would get. And so that book illuminates all of the trials and, you know, tribulations that Horace Tate went through, the death threats and so on, and everything he did to fight for equality during the days of Jim Crow. And the second book is about the initial segregation and integration of Gainesville City Schools up in Gainesville, Georgia. Is about an hour north of here. And you see it's a book, again, by Professor Siddlewalker with Ulysses Bias. And Ulysses Bias was a GA member as well. He helped argue for the merger back in the late 60s and 1970s. And he became one of the grand old men, I would say, of GAE. He has since passed away. But another fabulous book, if you want to read about what Dr. Bias did to create a preeminent Black high school in Gainesville City and what they went through after Brown to integrate. And then there's a number 3, again, a paper by Vanessa Siddlewalker doing a really, that's an academic paper. I eat that stuff up. It might put others asleep, but it really gets in a very fine grain detail of the start of the GT&EA. That paper, Organized Resistance, is about the creation of the GT&EA, and she pinpoints the start in 1878 when a fellow by the name of Richard R. Wright Sr. called a convening of 300 Black educators in Atlanta and said, hey, what are we going to do to organize Black education in the South? So it's a good paper. And the last book is by Professor Leslie Fenwick of Howard University. Again, she studies Black education, both in the past and in current times. And her book is very influential, me and many, many other folks, Jim Crow Pink Slip, which catalogs what happened after Brown. And it details the very sad but truthful history in many states, including Georgia, rather than integrate and put Black, highly qualified Black educators in classrooms and in leadership positions, principals and assistant principals. Thousands, up to 100,000 Black educators were fired across the country, but mostly in the Jim Crow South. It's a fabulous book. It's short. NEA figures prominently in this book because a lot of the book is about the Senate hearings that were convened to document how integration was going or wasn't going, and NEA submitted amicus briefs and arguments and data from around the country and submitted it to the Senate committee. And I believe it was Walter Mondale, former vice president, who was the chair of the committee at the time monitoring integration. So if you have time and are interested, I'd recommend getting Dr. Fenwick's book. So before we begin to wade into contracts, you know, I need to raise awareness of waivers, because some of your statutory contract rights, depending on where you work, may or may not have been waived off the statute book. So there are 3 models of educational delivery systems in Georgia. One's a traditional model. And then there are these 2 strategic waiver school system model, which allows a school district to decide to ignore what used to be mandatory state laws like class size or certification requirements, a state salary schedule, your duty-free lunch. And the idea behind these waivers is that by waiving these, onerous governmental regulations, we will see student achievement go through the roof. And as you see there, a little sarcastic, Scouts honor. No evidence that waiving any educational law has fulfilled the goals of increasing student achievement. So strategic waiver, pick and choose. The next one is a charter school system whereby the district waives all of Title 20 laws, that's the education code, with a few exceptions, like bullying laws. They can't waive something like a bullying law, but they can waive your teacher contract rights. They can waive your fair dismissal rights. They can waive your certification requirement that a person be certified in the classroom. All those things that we hold near and dear to our hearts in a traditional public education system. And again, so a lot depends on who we elect to your local school boards. And the last thing I'd say, so coming out of this, your homework, if you don't know, you need to go to your school district's website or the State Board of Education and find your school system and determine, are you a strategic waiver school system or do you work in a charter school system? And then you'll be getting a better idea of what working conditions you have there, and what rights you still have and those that you don't. The last thing is that, so what do you do when they waive them? Well, your school board can amend its charter to say, oh, we're now going to comply with the class size rule, or we are now amending our charter to comply with the state salary schedule. They can do that, but it only comes through political organizing, electing school board members that truly believe in a fair and equal and just public education system. Of course, the other way, and you may have more success doing it at the local level. The other route is that the General Assembly at the State House can restore your rights. They can do it in a complete overhaul or reversal of the waiver laws. I doubt that would be happening, but maybe they're open to some amendments to some of these waiver laws that make sense. Smaller class sizes, you are going to have higher student achievement. But when you load up your classes with more kids, obviously poses great challenges, and the data doesn't support that. Larger class sizes leads to greater student achievement. So maybe we can convince the legislature to do some amendment work on the waiver laws here in Georgia. So a few words about, I just feel it's important in these discussions about contracts. You also hear about right to work. Georgia's a right to work law. And so, so what's that mean? What it really means is in that second paragraph there, it says right to work means that you cannot be compelled to join a union as a condition of employment, right? That's in the private sector as well in the public sector. You can't be forced or required to join a union. That's all that right to work means. I mean, in a nutshell, in a very, very tight summary, to me, right to work means right to work for less, because these are anti-union laws, anti-organizing laws designed to, benefit corporations to make more money at the lowest possible cost, meaning lowest possible wages for its workers, including you, public school educators, currently do not enjoy the right to collectively bargain in Georgia. But that's something that we are continually fighting for. So we had right to work. It means you can't be compelled to join a union as a term and condition of employment. Well, then how is that different from at will? Well, statutes overlap somewhat, but at will means not so much that you can't be compelled to join a union, but it means that you don't have a continuing contract. You don't have a contract of a definite term like teachers do. You have contracts for a definite term that cannot be terminated in most instances without due process. Again, unless your district has done the genius thing of waiving those due process rights. At will comes into play with our classified employees, or as a membership category here at GAA, our ESP, educational support personnel, school bus drivers, lunchroom workers, administrative assistants, para-educators do not have a contract for a definite term, means that, and this is very harsh, it can be terminated or let go for a good reason, a bad reason, or no reason at all. It's very harsh. And Georgia is only one of 2 states in the United States that doesn't have any exceptions to those at-will employment rules. Like some states say, if you were, excuse me, fired in bad faith, you would have a claim. You could sue the employer if you're able to prove they were fired in bad faith. So there are no checks and balances in Georgia on at-will employment. Now, what I find interesting at will here in Georgia, surprise, surprise, the origins can be traced to the days of slavery. And actually, they go back before slavery to Europe. But the first Georgia Supreme Court case to report and set out judicial doctrine was issued in 1853. And you can read the slide. It was involved a plantation owner and a overseer. Overseer sues for wages, and the court said, yeah, that's all well, fine and good, but you didn't have a contract for a definite term, so the plantation owner didn't have to pay the overseer any wages. So in that 1853, if you were writing a brief to the Georgia Supreme Court on a contract case, you could cite that as perfectly good, valid law here in Georgia. And there's a resource there for those who are interested in learning more. What is that? Professor Ballum out at in the Berkeley Journal of Employment Law and Labor Law writes about puts it in a historical perspective, that at-will employment just didn't magically appear. It has, roots in slavery, because the slaves were chattel slavery. They didn't have any rights, basically. Then there were indentured servants who virtually had no rights. They were, hired to work off a debt, but those relationships were gamed. So between slavery and indentured servitude, that means a very docile workforce. And that's how at-will employment became so entrenched here. And what's left are a white working class of worker here in the South. And they were just willing to work at very, very low wages. They might have had contract rights to have employment contracts, but they didn't have any real true bargaining power as a result. But it's all explained in Professor Ballum's paper. I'm going to skip this. This is just showing you that the at-will employment rule has been codified in the Georgia Code, Title 34. Okay, so I get into contract, easing into it. This is first year law school. You spend a whole year trying to understand what an offer is and acceptance is and what is consideration. You need those three things as essential elements to a contract. And you also need, if you have a contract, it also has to be able to be enforced in a court of law. It's really those three, and the fourth one are what constitutes the basic elements of a contract. So what's a teacher contract? You know, it's an offer, acceptance, and consideration, and they're enforceable, right? Okay. But teacher contracts are governed by a state education statute, 20-2-211. And if you Google that and go to that section, you're going to learn this whole presentation that contains all the nuts and bolts of what governs teacher contracts and the renewal of teacher contracts. One of the provisions in the statute talks about an offer. Back in the day, school districts would send out letters of intent to their employees, asking them to complete it, stating whether or not you intend to return for the school year. And really, without telling them, people would say, I plan to return. And the school system would say, well, that's really, that offer is really a binding contract. And GAE, you know, we all lawyers got so tired of telling the districts, no, that's not so. We actually got the Georgia General Assembly to amend 20-2-211 to state that a letter of intent is not a valid offer. It's just so it's a you know, counting heads or counting noses type sheet, but they can't hold you to it as a contract. And then you also have to be in mind, so if you have a valid offer, what is your contract review period? Well, there's a statute, 20-2-942. It provides that teacher contracts, you have up to 10 days to review your contract. But you need to see, you know, if the district's not telling you in the cover letter attached to your contract how many days you have to return it, you should look at your board policy manual to see, have you waived that law, 20-2-942? So the rule is you always got to check your local policy. Now, if they've waived it, now they can then say, you know, you have 3 days to review it. And that would be legal. That would be legal. May not be fair, but it's legal. So you have a valid offer, you have a review period. Now comes the acceptance part of a valid contract. Is your signature is evidence of your intent to return, as is the superintendent's signature on the contract. Now that has to go to the local board of education as the final, you know, stamp of approval on the employment relationship. The superintendent recommends employment, but the board of education is your employer. Superintendent's not your employer. The board of education is. Now, the superintendent has administrative responsibilities to oversee policies and procedures and implement what the board of education wants to see happen. But the board of education is your employer. And as we'll see later, the approval or non-approval of your contract also comes into play if you're going to resign or rescind an offer of employment, or rescind a resignation. Get into that. So some tips: always read your contract. You know, we're in a teacher shortage era, and so rather than improve your working conditions, some districts find a retention policy by having something called liquidated damages in your contract, meaning that if you want to get out of your contract, you have to pay them a sum of money to get out. Some districts charge up, $750, some charge $1,000. But read your contract to see whether or not you have the get out of jail free card, liquidated damages before you sign it. And yes, those are, we fight the fight here. In appropriate cases, we have sued school districts, Lisa's school district being one, DeKalb, and over liquidated damages a number of years ago, and they have not put liquidated damages back in DeKalb County contracts since. Another thing to keep in mind is, we learned, Lisa told us that contracts went out in the Metro District last week. It's pretty early January, but there's no statute that puts brakes or sets limits or governs how early contracts must be offered or can be offered. And I, put in there a little, well, can they offer it at the Christmas time before you leave in the holidays? Well, they could, wouldn't make a whole lot of sense, but the point is there's no law on the books that tell them by what date they can offer a contract. And then you'd say, well, Mike, if they put a law on the books, could they waive it? And I'd say, yeah, they could, unless we force them to say this law cannot be waived. Then we would have something solid on the books. Georgia law requires contracts shall be complete in all terms, including the amount of compensation. That's a sore point, which we have litigated here at GAE. The amount of compensation, does that mean a numerical amount on the contract? $45,000, Mike's annual salary based on his years of experience and highest certification level is $45,389.23. Is that what the statutory language mean, the amount of compensation to be paid during the ensuing school year? Well, we fought the good fight, and unfortunately, the Georgia Supreme Court said, no, it doesn't mean a numerical amount of, $45,389.23. It means that all the district has to put in your contract to comply with the statute is to put your highest level of certification and the number of years experience, and that complies with the amount of compensation language in the statute. We fought the good fight and we lost, but no other organization is going to go to bat in court on these really key fundamental questions that we have as an educational community. The last thing, if you're not aware, is that signing a contract is a contract with the district. It's not with a specific school location or even a specific position, unless it states a specific position. If it just says teacher, that means they can move you to any place in the district to which you're certified to teach. It's just not, you could be at a school 10 years, you love the place, you feel that you become part of the school, and for the good of the school district, they could move you to a different location, and we wouldn't have a legal leg to stand on to prevent that, unless the legislature passes a law. So we get into some important dates. 20-2-211 says that school districts must offer the contract by May 15th. So the 25-26 contract must be offered by May 15th. Okay, must be, or if it's not offered, the superintendent has to provide a written notice of non-renewal postmarked by May 15th. There's a court case that said, does that written notice to say like a first-year teacher, must that be sent to that first-year teacher certified mail? The answer was no. Only if you have acquired tenure rights must that notice of non-renewal be sent by certified mail or overnight delivery, and that is defined in the fair dismissal law. But if you haven't acquired tenure, then the superintendent's letter can be, hand delivered or sent first class mail. Now, if you haven't gotten a contract by May 15th and you haven't gotten a letter, then that's actually good news. I think it's on the next slide. Yeah. It says that if you don't get the contract by May 15th, then you don't get a letter from the superintendent, at least postmarked by May 15th, that you're not returning. There's no offer forthcoming. Your contract's automatically renewed by magic of law. Okay. The next important date to know is, well, if you have a contract, it's been offered, you sign it for next year, you have a right to resign no later than June 1, okay? That's our view, GAE's view of the contract, okay? Now it can get a little tricky. Again, I hate it. Your school district might have waived these two important contract provisions. In other words, if you're in a district that waived this statute, contracts go out, I sign it, even though this statute says, well, I can resign by June 1, the district can come back and say, well, Mike, well, we waived your right to resign by June 1st. Well, GA will still go to bat for you and advocate for you to be released from your contract. And one of the reasons we have a good track record of getting people out of contracts prior to June 1st, still important, because the Professional Standards Commission doesn't sanction certificates if you resign prior to June 1. That's a big leverage or a big hammer that could be employed on folks. The PSC used to have a more generous view of it. Up to a couple of years ago, PSC stated that they would not sanction you if you resigned prior to June 15th. But I believe it was in 2018, they rolled back your rights and said they won't sanction your license if you resign prior to June 1. That's still a benefit, very important for everybody on this call to know. Let's see, written request. Oh, the other thing in the contract statute 20-2-211, that if you don't have tenure, you can ask the school district or superintendent to provide you the reasons why your contract's not being renewed. And having touched that fire once, I'm of the opinion that don't ask them the reason in writing, because that gives the district an opportunity to put every negative thing that they can think of into a document that then goes into your personnel file that wasn't there yesterday. So even though that law's on the books, and oh, by the way, one of the competitor organizations supported that language when Governor Barnes, what am I trying to say, Lisa? He abolished tenure. He abolished tenure back in the early aughts. And a competitor organization said, well, he's abolishing tenure, but hey, you can ask for the reasons for not renewing my contract. And we're going to, as an education organization, we're going to support that. That was a competitor, and it was not GAE. In fact, we worked very hard to make sure that Governor Barnes paid a price at the polls. And the rest is history. So this is just a little bit more of what due process rights are. And, I really hope and pray that your district hasn't waived fair dismissal. because what it does, it levels the playing field. The district has to provide you a detailed statement of all of the reasons as why they're not offering you a contract. And a list of the witnesses that they propose are going to testify against you at a hearing, and a summary of the proposed testimony that the district says that these witnesses are going to say. Those are very valuable rights that are only there to protect against arbitrary and capricious firings and political firings. If you don't, if you upset a parent, it takes one parent to agitate the superintendent and school board to terminate an educator. So, please check your local policy. Now, if they have waived the fair dismissal statute, they should have a fair dismissal policy in their board policy manual. And I know off the top of my head, Fulton County is a charter school district that waived fair dismissal, but they do have a fair dismissal policy as a board policy that they have followed it over the years. The major sticking point is the way the law is now is that if we lose a fair dismissal hearing in Fulton County, there's no appeal to the State Board of Education. So, we got to place all of our eggs in one basket and shoot for the moon in front of the board in Fulton County or any other county that hasn't waived fair dismissal. I can say DeKalb has not waived fair dismissal. So by contrast, if we had a non-renewal hearing of a tenured educator in DeKalb County and we lost at the school board level, we would have a right to appeal it to the State Board of Education, right? The way it should be. Tenure, just a word about tenure. That word actually does not appear in the Fair Dismissal Act as it applies to teachers. The word tenure applies in part of the statute that applies to administrators, but not as to teachers. And it basically means that if you're a teacher that's worked 4 consecutive school year contracts with the same school district, you have rights to due process if they are going to not offer you a contract for the following year. The statute says all you have to do is accept that 4th contract. It does not say you have to work that 4th contract. And I've seen a few cases over the years where we've got into situations where they've tried to say the educator didn't have tenure because they didn't work that 4th contract. And we'd say, no, read the plain language of the statute, and if you want to go to court, we'll sue you, and we're confident of prevailing. So, this is probably what most people have come to learn about is, how do I get out of my contract? How do I get out? Well, I have 2 ways: a release or a resignation. Again, refer to your own contract and local board policies to see what policy and language governs releases or resignations. And so, very simply, a release is a grant by the district to get out of a contract. There is no right to a release. We cannot demand to be released from a contract. It must be approved by the superintendent and approved by the Board of Education. A resignation, on the other hand, is a unilateral act. It means if I have a contract and Mike doesn't want to teach anymore, Mike can unilaterally say, so long, farewell, been nice knowing you, and I can leave. Mike can resign unilaterally, but there will be consequences, right? There will be consequences for a unilateral resignation. I think I've hit on the PSC views these issues pretty uniformly across the board. If they come across a breach of contract where you did not if you did not resign in a manner that assists the school district, or you weren't granted a release, they'll just automatically recommend a 90-day suspension of your license. And if you're a GAE member, that will assign a network attorney, and we'll have a hearing to determine whether or not that recommendation should stand. So to getting into the code of ethics, and the code of ethics governs contracts as well. So they consider it a breach of contract, and this is from the definition section of the code of ethics. And there's the address to go look at the code of ethics, gapsc.com, go to ethics. You can look at the code of ethics tab to read the code of ethics. And if you go to resources, you can look at the guidelines for breach of contract. That's a very important document that I suggest everybody open up, take a look at, perhaps print off and keep handy. So the guidelines say that they won't sanction a license, if you resign prior to June 1. Now, here's the big sticking point. Comma problem, they would say, well, sure, Mike, we'll accept your resignation, or we'll grant you a release only when we find a suitable replacement. And there is no bright line test. There is no black and white answer here. This is the gray area. We have a far stronger position to argue to get out of a contract before June 1. But believe me, the districts, they pay attention to that June 1 date just as much as we do. And once we get past June 1, they can just point, to either the state statute 20-2-211 or the PSC guidelines. But we still advocate, and we will still argue on your behalf. Say you had an offer of employment elsewhere, and it's June 2nd. Well, those are good facts. We'd say, well, hey, we missed the June 1 deadline, but it's June 2nd. What's the harm here? You still have all summer to find that suitable replacement. And a lot of districts are actually, open to that. They're really not out to, in most cases, really to, harm a career. But as you can imagine, the closer we get to the opening day of school, the harder it is going to be to get out of a contract, even if you are going to be paid more money in another district. Now, the exception is if you get a promotion in the field of education. So after June 1, clearly one of the PSC guidelines for breach of contract says that they will not sanction you after June 1 if your offer of employment is for a promotion within the field of education. And so that could be right from the classroom to administration. That's easy. And it could be, in their interpretation, finally comports with, how about if I go from classroom teacher in County A, but in County B, I'm classroom teacher, but as a department chair, and I get a stipend for that. Is that a promotion? And the PSC these days, not in the beginning, but these days would say, yeah, that's a promotion, and they won't sanction your license. The other thing to keep in mind in these situations, they're very painful. It's between a rock and a hard place. The county that is accepting you or offering you this job, will they accept a unilateral resignation, or are they going to require only the release from your district? And nowadays, there's a sanction in these guidelines for breach of contract that says something like, I don't have it in front of me, but if an administrator offers a contract after June 1 to an educator that is under contract with another district, they can sanction that administrator. So that's why it gets very hard to get out of a contract after June 1. Many districts are going to insist on that release. Couple things about teacher contracts. They are tied to performance evaluations. If you get 2 unremediated, unsatisfactory ratings in your previous 5-year certificate renewal, the PSC will not renew your license. And guess what? No appeal process for that. How about them apples? So, we got to work hard and we got to pressure the General Assembly and the PSC specifically to adopt a rule that gives you the right to appeal from the denial of a license if you have those 2 unremediated, unsatisfactory ratings. And a lot of these situations, it's not the educator's fault, is that administrators don't like somebody and will mark somebody down a 2 when it was really a 3, but they mark Mike down as a 2 because they think Mike is, whatever. So we need to have an appeal process in place. So what we're doing to fight, this is the case I mentioned sort of tongue-in-cheek about Lisa earlier, is that we sued DeKalb a number of years ago. And we got the court to agree with with us and created a jury question on whether or not their $750 was a fictitious number, or was it really based on injury to the district? And we had the HR director testifying. She didn't really know. We kind of came with a committee, and we decided 750 sounded like a good idea. And at that time, Michael Thurman, a great guy, a great county executive, all around good human being, he testified under oath as well. It's like he didn't know how they came up with $750. Well, that was an embarrassing moment for them in the litigation. And as I say, they didn't want to go to trial. They knew they were going to lose. And so what we agreed on was a court-administered reimbursement system. And the district put $110,000 in the pot of money at the court. And if you filled out a form that you met the criteria of not having, having $750 taken out of your 2017-2018 contract, they would reimburse you that $750. And the district also agreed to repay GA $50,000 in attorney's fees. Well, we also had the same thing happen in Griffin Spalding around the same time, I think, a little bit after the DeKalb settled. But what's interesting in Griffin Spalding is that the school district said that GAE was unprofessional and declared war on the district by suing, advocating for our members by filing this lawsuit on liquidated damages. And so they threatened to take away payroll deduction of GAE dues from the payroll system. Well, if that's not a violation of the First Amendment, right of association and right of speech, I don't know what is. And so at that moment, the NEA helped jump in and help fund the First Amendment lawsuit against Griffin Spalding for threatening to take away, or, really did take away our payroll deduction slot simply because we had filed a lawsuit. And I think 30 days after we filed, the school district waved the white flag of surrender And we won the First Amendment lawsuit, and we again vindicated Nikita Jones and Cheryl Clark, and got them their $750 back where it belonged. A couple other cases that we have fought since the beginning. Atlanta schools had this when they became a charter school system in 2016. They had this fancy plan, a turnaround, and I think it was the Carver High School cluster was designated, low performing, or whatever negative, label they wanted to thrust upon the Carver cluster. And so their plan was to fire everybody at, let's see, I'm trying to think of the schools over there in the Carver cluster. Anybody from Atlanta might be able to. Gideon's Elementary, Price Middle, Thomasville Heights, Slater Elementary. They're just going to fire everybody for being in a low performing school and have private education management companies manage the school, purpose-built school. And what is it, Candace?
Yeah.
Private education.
Yes. Desi.
Yeah. And so we filed a suit saying, you can't do that. These people, the teachers had due process rights, and the court dismissed it on these just really bizarre lack of standing type of arguments. Didn't even get to the merits of the case. So it was, just poorly handled by the judges in this case. So we lost, we tried, but we lost, case dismissed. Floyd County Charter System, we similarly filed suit on behalf of a member, Rhonda Ware. Some of you may remember Rhonda. Rhonda had tenure in Floyd County. And we said, well, she has tenure and you could non-renew her. And if you did, you've waived her fair dismissal rights. Well, the court came up with, I'm sorry, a made-up reason saying, well, Miss Ware hasn't been injured, she could possibly be non-renewed. And they said that isn't enough injury. So they, again, dismissed it on what they call standing grounds. Rhonda Ware didn't have standing because she didn't lose her job. Again, in another state, we could have won, but the judges here are quite conservative. And the last one where we thought we had the best chance of all was against the Fannin County Charter System, and it presented a set of facts that could not be ignored, that put the question fairly squarely before the courts. Miss Susan Barnes had acquired tenure rights with Fannin Charter, with Fannin Public School System before they charterized, and then they non-renewed her for some, really minor, sort of interaction with a student. It was just very minor. She was trying to discipline a student. The student got upset. The parent got upset. And they said, goodbye, Miss Barnes, after 17 years, no due process. Well, the argument we had was, very solid and recognized in other states like North Carolina that said that because she had acquired tenure rights before you became a charter system, you had a vested constitutional contract, number one, and number two, you cannot apply that charter system waiver retroactively. It can only be applied prospectively against individuals who have been hired after you became a charter school system. And so we got that decision back in 2024. That case started in 2017. Long trail. the courts move slower than glaciers, it seems, but we got the answer back, which disappointing, which leaves us back with the state legislature. If we want to protect our rights, we need to persuade the state legislature or your local board of education. If they have waived your fair dismissal rights, they can undo that, but we have to elect people who are really have your best interests in mind, the best interests of a, adequately funded, free, fair, equal public education system. Well, that's it. That's my presentation on teacher contracts. We thank you for your membership, GA members. As you know, there's strength in numbers. We're stronger together. And Legal Services is there to support you. So thank you for your time and attention. I hope you learned something. Lisa, muted.
Of course I am. And if you can share the 2 slides I sent you. So for those of you who are here this evening, you're going to want to look for your school system. And one of the things you need to know is every school system, if you watched this presentation last year, we showed you the list of school systems who are waiver systems that have waived the teacher contract law. And last year, January 2024, there were 20 systems. This summer, all the strategic waiver systems renewed their contracts. So this first list is the 48 school systems in Georgia who are charter systems, and they have the blanket waiver. So they need, if your system's on here, you need to review your local policies about what they're going to comply with for your contract. And Mike, if you go to the next slide, we jumped from 20 to 45 systems that have waived 20-2-211. So if your system is on this slide, they have waived the law concerning your teaching contract. Some of them, and they had to say why they're waiving it. So I put the link earlier where you can go to pull up your system's waivers. For example, a couple of these systems said they were waiving the contract law because they want to offer teachers a multi-year contract. Okay, we don't know if any of them have done that yet, but that's the reason they said they were waiving it. There was one system that literally said we're waiving the law because we don't want to include a dollar amount in the contract, so we can cut pay after teachers have signed the contract. So you need to go look and see what your system said about why they were waiving it. And then when you receive your contract, you need to ask the question, what do I need to do? What are my rights about this contract before you sign? So just wanted to make sure everybody was able to see that. And thank you, Mike. We have someone in the chat that said, I learn something new every year, and I agree. Thank you so much for being with us this evening. You all have a great evening. And again, thank you for being a member of GAE.